Good morning everyone. This is Professor Dr. M.R.K. Prasad, VM Silgaonkar College of Law, Panaji, Goa. Today we will be looking at clinical legal education, law schools and legal aid. The structure for today's presentation: first we will be discussing what do we mean by access to justice, and after that how the legal education in India is going to help in achieving the access to justice. There we would be discussing on the structure of Indian legal education, and then thereafter we will look into clinical legal education. What are the goals of this clinical legal education? Thereafter we will be looking at how this clinical legal education in India has emerged, developed, and we would also look into the clinical legal education's role in providing access to justice. Thereafter we would see what are the challenges that we are going to face, and also we would be focusing on opportunities that we have in providing legal aid to the poor through clinical legal education. So let us look into the first concept, what is access to justice. We look at the constitutional goals starting with the preamble. The preamble tells us that the Constitution wanted to provide justice, liberty and equality to its citizens. So these reflections of the preamble were well captured under Article 14, 21, 22 and 39 and some other articles. Article 14 talks about equality before law and equal protection of the laws. So therefore, under Article 14, the state shall not deny any person equality before law, which includes an equal opportunity to access to justice for whose rights are violated. And similarly, Article 21, which talks about no person shall be deprived of his life and liberty except according to the procedure established by law, due to the Supreme Court's interpretation in Maneka Gandhi case, such a procedure must be just, fair and reasonable. Therefore, any person whose rights are violated should have an equal opportunity for access to justice. If it is not so, such a procedure would amount to unjust, unfair and would violate Article 21. Similarly, Article 22 clause 1 specifically provides a right to counsel of his own choice in case a person is arrested. However, if a person could not be able to afford to appoint a lawyer of his choice, then it becomes a fundamental right for the arrested persons to claim free legal aid under Article 21, as without lawyer the procedure established by law would not be fulfilled. Similarly, by 42nd Amendment under Directive Principles of State Policy, Article 39A was inserted, which now specifically says that free legal aid is the duty of the state. Similarly, in addition to the constitutional protection, there are several statutory protections for the purpose of providing access to justice. To start with the Civil Procedure Code, Order 33, where in a civil suit, if a person is unable to defend himself, the state has to provide free legal aid. In similar lines, the Criminal Procedure Code, Section 304, also provides free legal aid to the persons who cannot afford a lawyer. And even the Advocates Act 1961, Section 9A talks about the legal aid, and it is not only the state's obligation, but also it is a professional obligation for the lawyers to provide legal aid under Bar Council of India Rules 1995. Rule 46 clearly says that the lawyer cannot refuse to defend a client only because the client will not be in a position to pay. However, the Rule 46 says within the economic capacity of the lawyer, it is the duty of the lawyer to provide free legal aid. But in 1987, finally, the central government has passed a comprehensive legislation for providing free legal aid, the Legal Service Authorities Act 1987, under which the Section 12 prescribes the categories of persons who are entitled for legal aid. So therefore, under Legal Service Authorities Act, once a person is covered under Article 12, it becomes a statutory right to claim free legal aid, and it is not only providing legal aid under the Legal Service Authority, also provides 3-tier system to provide such a protection at district level, at the state level and at the national level. So, these are the 3 authorities created for the purpose of providing legal aid to the deserved persons under section 12. However, providing legal aid, though it was given to the state responsibility, by looking at the sheer number of the people who are entitled for legal aid under section 12 of the Legal Service Authorities Act, it is imperative to see how legal education in India could step in to fulfill that obligation. So, for that, first we need to understand and assess the status of legal education in India. Legal education in India is imparted by different colleges. There are law schools which are completely funded and managed by the government, and there are university law colleges. Though the funding is received from the government, they are controlled and managed by the universities, and there are private institutions managed by the private but financially aided by the government. There are private managed colleges where the management and finance both looked after by the private people. Then there are private universities which are again managed and financed by the private, and lastly the national law schools. Again, national law schools were established specifically to impart 5 years legal education. Again, they receive funding from the government and also they raise their own funds. So, these are the various schools that offer legal aid, legal education in India. And this legal education in India is controlled by several agencies. However, the legal education is predominantly controlled by the Bar Council of India. The Bar Council of India looks into the curriculum and also the minimum infrastructural facilities that the law schools should have, and Bar Council of India under the Advocates Act was given power to look into the legal education. Therefore, Bar Council has come up with their own rules and regulations regarding recognition of the law colleges. Unless the Bar Council recognizes, the students who are obtaining degrees from these law schools cannot practice in court of law. In that sense, Bar Council of India has a larger control on administration of law schools in India. The second body that could monitor the law colleges is the University Grants Commission. The Bar Council prescribes the curriculum, but usually the University Grants Commission, which gives the detailed syllabus of curriculum, and also they monitor the service conditions of the teachers and teaching hours, etc. In addition to University Grant Commission, the colleges which are affiliated to a university, the affiliating university also imposes restrictions on appointment, service conditions of the teachers and standards of legal education. In addition to that, the state government, in case of giving funding, etc., also imposes certain restrictions and also monitors it. In case of private managed colleges, in addition to all these 4 agencies, even the private management would also monitor and also control the legal education. So, therefore, there is a multiple players controls the legal education in India, often sometimes causes confusion and conflict of monitoring. The structure of the legal education, if you look at in India, is basically started in the beginning with 2 years for LLB course. However, after Advocates Act was passed by the central government, after establishing of Bar Council of India, the Bar Council of India brought a uniformity throughout the country by bringing into 3 years. So, the 3 years course could be pursued by the students after completing any graduation. However, the Bar Council of India felt that the 5 years course would have been better than 3 years course in the lines of engineering and medicine to create more professionalism among the students. A 5 years course was introduced, and the 5 years course was termed as 5 years integrated course. It becomes integrated course in the sense that not only the law subjects, but also the subjects like sociology, history, political science, economics were also taught during the LLB program. However, this 5 years LLB program could be joined by any student after 12th standard. However, in 2008, further reforms were brought into the legal education by the Bar Council of India. In 2008, a 5-year double degree integrated course was introduced. The idea of 5 years double degree integrated course is, after completion of the 5 years, the students would get 2 degrees. For example, they may pursue their LLB degree in a BA LLB, where they get both BA as well as LLB after completion of 5 years. Similarly, they have BBA LLB, they have BCom LLB, they have BSc LLB. It all depends upon the institution which course they can introduce and they can offer. So, the advantage of this course is that a student who join in 5 years LLB course, after the completion of 5 years, they will get 2 degrees, whereas if you do graduation and come to the law, then you need 1 more year, that is 6 years. So, the advantage of 5 years double degree program is 1 year leeway was given to the students. Now, in India, they have more than 1100 law colleges, and probably every year more than 1 lakh students graduating and joining in the bar. And in terms of registration to the Bar Council, India is the largest country where have largest number of lawyers registered. So, therefore, the legal education in India is a very important stakeholder in promoting and providing access to justice. Hence, if it is going to play such an important role, what should be the goal of this legal education? Unfortunately, there is no such attempt was made by anyone to define or to identify what are the goals of legal education, because unless the goals were identified, the imparting of the legal education has no meaning. Once you determine what are the goals, the legal education need to be designed to reach or achieve those goals. However, Professor Madhav Menon, who is a legal luminary in this country, has identified certain goals for a legal education, which we would just browse through them. The first goal that the legal education should have, according to Professor Menon, is that the legal education should direct and moderate the social change. So, the legal education not necessarily just to become a lawyer, but the persons who are graduating from the law schools should direct and moderate the social change, and such a goal becomes important by looking at the fact that the Indian independence movement was virtually led by the lawyers, and he also suggests that the legal education should manifest higher moral values, which is very much in need, and also he focuses on that the degree of competence and discipline that the legal education should provide to the lawyers. And furthermore, very important aspect, particularly in terms of access to justice, is that he says that the legal education must ensure that no section of the society is denied of access to its services because of poverty or a social status. So, this is the most important goal, that the legal education should ensure free and affordable services. And further he goes on and says that the legal education is also to influence the governmental policies towards providing social justice, and also it should increase efficiency and promote excellence. Suppose these are the accepted goals of legal education in India. Let us answer few questions. The first question I want to answer is that, do people require legal services to defend them? Of course, it is a very obvious question. Everybody knows that all people are not legally literate, therefore, obviously they need legal services, and there is no second thought about it. But do you think that the people could represent in a simple matters? If complex matters, you could appoint a lawyer, but what about the simple matters? Do we need a lawyer for simple matters? And again, of course, if I take an analogy from medicine, if you have a slight headache, would you able to think that it is an ordinary headache, not a migraine or something? Could you able to decide, or you would go to a doctor and take an advice? So therefore, what is simple for a lawyer or a judge or a law teacher may not be simple for an ordinary layman. Hence, there is no reason to say that people can represent themselves even simple matters. Simple matters are for us, not for the layman. So next question would be, okay, we agree that even simple matters the legal aid is required or the legal representation is required for the litigants. But again the question is whether the legal aid should be provided only for litigation. If that is so, what happens that where a legal aid is not provided when you are not going to the court? If you look at the most, or we would say the vast majority of the experiences where legal remedies are available, not requires to go to a court by way of litigation. For example, if you want to draft an RTI application or want to claim some information from a government, you do not litigate. But if the person does not know how to write an RTI application, or if a person was asked to submit an affidavit, whether legal aid should be provided for those people. So it looks like that the legal aid does not mean that only legal aid when a case was filed against a person, or it is only a litigation services. So more than litigation services, the legal advice and legal aid is required for many other areas. So that is why I want to divide these legal services into inside litigation services and outside litigation services. If you look at the inside litigation services, what I mean is that the purpose of such services is to assist the people who are defending the cases or who is ascertaining their legal rights in a court of law, where we have no hesitation to say that legal aid is necessary. But the second category, the outside litigation services, that is assisting the people which legal matters where litigation is not an option or unlikely to be involved. For example, if a person who wanted to stand as a surety wanted to know what would be his liability if he stands as a surety, obviously such an advice does not require to be a part of litigation, but it is only a legal advice to take a decision. So therefore, the legal aid cannot be restricted only to inside litigations, but it should be given even for the outside litigations. However, if you look at most of the statutory provisions, they talk about inside litigation services rather than outside litigation services. So therefore, the question for us is what kind of legal aid that we should give. To answer that, we should know what is legal aid. There are three reports written by Justice Krishna Iyer and Justice P. N. Bhagavati, which listed 7 components of legal aid. The first component of legal aid is legal representation, which we talked about inside litigation. That means where a person who wanted to defend a case or who wanted to file a case to protect his right, he requires a legal representation. That is where you have to give a legal aid if the person is not able to afford for a lawyer. The second component of legal aid is legal advice. So here the legal advice is outside the litigation, where a person wanted to know whether he could enter into a contract, what would be the consequences of doing a particular action. So these are legal advices where not necessarily results in litigation. And the third and the most important aspect of the legal aid is providing legal awareness. If you look at in India, even in case they are literate, but they are not legally literate. Therefore, legal literacy becomes the fundamental concept of legal aid. Unless you are legally literate, you are not in a position to protect your rights. Therefore, providing legal literacy is also a part of legal aid. Similarly, the fourth category that they identified is the paralegal services. The paralegal services are the services which are not actually required by a lawyer to do it, but somebody who has some kind of knowledge about the law. For example, drafting affidavits, preparing memos, or sending legal notices, or even filling some of the forms for social welfare benefits, etc. So, all these paralegal services also becomes part of legal aid. And the fifth one is the public interest litigation. So, public interest litigation is also a part of legal aid, where the traditional legal aid what we are talking is for an individual purpose, whereas the public interest litigation is for the society at large. And the sixth one is promoting alternative dispute resolution, because every dispute need not go to the court. We have very vibrant alternative dispute resolutions mechanisms in place. So, therefore, promoting this alternative dispute resolution becomes part of legal aid. And the last one but not the least is the law reform. So, bringing changes in the law for effective implementation is also part of legal aid. So, these are the 7 components that the 3 reports has identified becomes part of legal aid. And now the question is whether the law schools or the law colleges could be able to provide all these 7 components of legal aid. So, to answer that first, of course, they can do that through legal aid cells or legal aid clinics what we call. So, the question why legal aid clinics are required to be established in the law colleges, we have already seen that the legal aid components are 7, but mostly the statutes talks about only 1 component, remaining 6 components were largely neglected. Hence, there need to be a legal aid clinic in the law college to address these areas. But the question is, what is the advantage of involving the law students in these legal aid clinics for the purpose of providing legal aid to the people? These are the following reasons why we want to involve law students. First, the law students can extend legal aid to the remote villages where the state may not be in a position to penetrate into such a remote areas. The second one is the students can provide legal aid and advise much cheaper cost, because if the same representation has to be given by the lawyer, it would cost more, whereas the law students can provide a cheaper cost. Third one is legal aid cells are also an excellent means of teaching professional responsibility. So, how do you teach a professional responsibility to a student? In a classroom setup it is not possible, it could be possible only in a clinical setup. Legal aid cells also can provide an excellent platform for the students to learn practical skills. Students who graduate from the law colleges, when they enter into the professions, they seriously lack these practical skills. Therefore, the clinics is an ideal setup to impart these skills. And the clinics also very effective instruments for community education. So, this community education has an impact of preventing preventive legal service programs. That means, it may in turn turn into preventing the litigation in the courts. So, the involving law colleges also improves the value of and reputation of the legal profession, which is very much needed. And therefore, if you properly channel the law colleges can meet the demands of the modern society, and it would help in transforming the society and to reach a desirable goals. Therefore, involving the law college students is a very good idea through clinical legal education. So, how do we do this clinical legal education? To understand clinical legal education, first we will look into the concept of clinical legal education and its goals. For the first time, the word clinical legal education is coined by Russian professor Alexander Lublinsky in 1901. The idea of clinical legal education, according to him, is that it should be in similar lines of medicine, where the students who are pursuing MBBS course not only studying in the classroom, but at the same time learning by visiting to the patients. In a similar lines, the law students, while learning law in the colleges, also should work in the legal aid clinics to get the practical knowledge. So, the law schools are predominantly looking at the legal doctrines, and therefore, the students are not completely equipped when they graduate from the law colleges. So, the debate that whether the law colleges are, it is a law colleges or lawyer colleges, it become redundant now, because everybody accepts that the law colleges are supposed to be responsible to impart the skills training to the students. So, let us look into the purpose of the clinical legal education. The purpose of the clinical legal education is to, number one, develop the perceptions and attitudes. So, when you join in a law college, a student comes with a different idea of what law is, but the clinical legal education would change those perceptions and attitudes of the students. And the second purpose of clinical legal education is to obviously impart skills, and the third one is inculcating the professional responsibilities. So, what are the goals of the clinical legal education? The goal of the clinical legal education is to develop a student professionally and intellectually. So, learning law by theories is not sufficient. Learning the law practically will give more knowledge to the student, and it also aims at turning law students competent and socially relevant lawyers. So, mere competence of lawyer is not sufficient unless they are socially relevant. However, socially relevant they are, if they are not competent also does not solve the purpose. And also, integrating the theory into practice is possible only through clinical legal education. And the most important aspect of the clinical legal education is equitable distribution of legal services in the society. That means, the marginalized people should also get the quality legal services at an affordable price. So, therefore, the clinical legal education's goals are being noble. We will look into how this clinical legal education has started in India, how it is originated and how it is developed. The clinical legal education in India began in legal aid movement in 1960s, and the law schools were expected to play a very significant role, and initial measures are voluntary by the several law colleges like Delhi University, Banaras Hindu University, etc. However, in 1998 Bar Council has made it compulsory as a practical paper, legal aid as a part of practical paper 4, and in 2008 the Bar Council has mandated all the law colleges should have a legal aid clinic. So, because of these efforts from the Bar Council, several colleges has made different attempts in creating legal aid clinics. Particularly, Goa is one of the best example, where Silgaonkar Law College has set up 40 community law centers in providing various range of legal services to the people. However, this clinical legal education has posed several challenges in India to start a legal aid clinic. I have listed few of them. The fundamental problem that the law colleges face to start a legal aid clinic is lack of financial support, and second one is the infrastructure facilities. Most of the law colleges are not in a position to provide proper infrastructure facilities for a legal aid clinic. And another glaring challenge, or we could say the deficiency in law schools, is the lack of trained faculty in providing or in operating legal aid clinics, because most of the faculty has no practical experiences. Therefore, a practical experience is most important in running a legal aid clinic. Therefore, that becomes a big concern. And the most important thing in this regarding the trained faculty is also the training facilities to the faculty. Neither the Bar Council nor any other institution was in a position to train the teachers to start a legal aid clinic and make the students to work under the legal aid clinic. And also, under the Advocates Act, the Bar Council imposes a restriction on the teaching faculty on practice in the court of law. Because the teachers are not practicing in the court of law, they lack practical knowledge. And also in many law schools, the legal aid is not made as a part of workload for the faculty. Therefore, that becomes an additional work for the faculty. And another glaring defect or we say deficiency is that lack of involvement of bar and bench in the legal aid activities of the law school clinics. And the restrictions on the student practice also does not help the cause, because the students, unless they graduate, they could not represent these clients in the court. That restricts the services that could be provided by the legal aid clinics. In addition to that, the part-time nature of the students, academic credit for the students, student quality also plays a major role in success of legal aid clinics. However, in spite of all these difficulties, there are several opportunities were given by the Bar Council by its 1998 and 2008 rules, because now it becomes a mandatory for each and every law college to start a legal aid clinic. And we have seen already the 7 components, out of which maximum the first component may not be able to be carried out by the legal aid clinics, but the remaining rest of the 6 components could be easily provided by the law school clinics. So therefore, here are the few opportunities I would like to present. Is that one is the legal literacy program, which is also called as the street law program in foreign countries. Now this legal literacy program is the most suitable for the legal aid clinics, and the law students could actually visit villages, remote places, and try to educate the people on legal matters. These legal literacy programs could be conducted through street plays or legal education programs, or even taking rallies, door-to-door campaigns, etc. So the legal literacy program is the most suitable for the law students, easily could be adopted by the law students in telling the people what are their rights, how those rights could be protected. The second opportunity that the law schools have is that the legal entitlement programs. The legal entitlement programs is basically that the state has offering several welfare benefits to the people, and they float several social economic schemes for the purpose of the poor and oppressed class. So this is where the law schools can play a very important role. Through their legal aid clinics, they can research on these welfare benefits, bring notice to the people that these welfare benefits are available, and work towards getting those welfare benefits, and also by research find out what lacks, and that what is lacking could be identified by the law schools and can ask the government to accordingly amend the schemes. The third opportunity is free legal advice clinics, where the students can provide advice on simple matters to the clients.
आप क्या करिए, वो एप्लीकेशन में लिखिए, ये मेरा काम है, मैं इतने दिन से मैं ऑफिस में चक्कर लगाता हूँ मगर मेरा काम नहीं हुआ है अब तक. आप लिख के उस ऑफिसर, इन्फॉर्मेशन ऑफिसर के हाथ में दीजिए. उसका हक बनता है कि 15 दिन में रिप्लाई दे कि क्यों आपका काम नहीं हुआ है आपका. उसके लिए ज्यादा पैसे नहीं लगते, 10 रुपये फॉर्म देना है एप्लीकेशन के लिए, नहीं तो आपके खाली पेपर में
जितना आपको वापस मिलता है ना, वो तो सरकारी पैसा होता है, वो देना पड़ता है. ज्यादा देने की बिल्कुल जरूरत नहीं है, क्योंकि वो सरकारी पैसा सिर्फ 2 रुपया होता है. 2 रुपये से ज्यादा देने की जरूरत नहीं है आपको, और पर कॉपी 2 रुपया होता है वो, जितना आपको वापस मिलता है.
अगर आपको डराता है, धमकाता है, चिल्लाता है, ये क्या ये सब नहीं है, तो वो उसका हक नहीं बनता है. आपका हक है कि पूछने के लिए, सवाल करने के लिए क्यों आपका काम नहीं बना है. आपको अगर चेतावनी देता है, चिल्लाता है, तो आप ग्रुप में जाइए, जो 5 लोगों को लेकर,
क्योंकि आपका हक बनता है जानकारी जानने का.
बैठते हैं तो जाते नहीं है कि आपको चिल्लाता है, नहीं चाहिए काम, ऐसे छोड़ के आ जाते हैं, घर में बैठ जाते हैं आप. तो ऐसे क्या होता है हमारे समाज में, क्या होगा, आप चुप बैठते हैं तो आपका आवाज उठाना पड़ेगा, आपको पूछना पड़ेगा कि.
In addition to that, as we already discussed, the paralegal service is part of the component of legal aid. The paralegal services could be very well done by the law students through their legal aid clinics, like filing RTA applications, helping the clients to draft affidavits, etc. Then in addition to that, the law schools also can conduct open forums to bring out the public problems to the view of government officials. Even though the Advocates Act prohibits the students from practicing the law in courts, but there is no such restriction when it comes to quasi-judicial bodies. Therefore, a pro bono representation in quasi-judicial bodies are very well possible under legal aid clinics. For example, a consumer clinic. Both the Salgaonkar Law College and National Law School of Bangalore both have these consumer clinics where they are fighting for the rights of the consumers in the district and state forums, and there is no restriction on representation. Similarly, the RTI clinic, again representing a person who wanted to collect information from any government body, could be represented by the students, and there is no such restriction as such that only lawyers can do that. The last and the most important aspect of the legal aid clinic is the public interest lawyering or the public interest litigation. Now, this is where the law schools can do a meaningful job. Whenever the law students found any violation of rights of the people or disadvantaged groups, the students can prefer a public interest litigation either in the High Court or in the Supreme Court. There are instances like National Law School Delhi and VM Salgaonkar College of Law in Goa has filed and intervened in several public interest litigations. So, this is an excellent method by which the students can provide access to justice to the poor and marginalized, and at the same time learn the skills of advocacy. So, thank you very much.